You need a puppy in your lap too.
I do. I could definitely use a puppy right now. Hey guys, so I am Chris Wilms. I'm one of the attorneys here at Hopler, Wilms and Hanna. We're a law firm in Durham, and I am joined today by David Crispin. He is a chartered special needs consultant and certified financial planner. And together we're going to be talking about things that special need caregivers need to know. David will be starting us off by talking a little bit about himself and what he does for special needs caregivers, and talking to us about some financial steps that can be taken to help those with special needs when you're no longer able to care for those folks yourselves. And so he'll be talking, and then I'll be going into a little more depth about one of his steps, and that's about special needs trust. There's a lot of misinformation and confusing information out there on the internet that may lead people down the wrong path. So we're going to give you kind of a primer on how trusts work in the special needs community, and some things to look out for, so that as you're doing your research, you'll be able to distinguish between various tools that are available for those with special needs. So I'm going to turn it over to David and let him talk. And David, if you could just introduce yourself and jump into it.
Of course, and I hope everybody does not mind that we're joined by our puppy here, Salem. She wanted to be a part of the conversation as well, and really appreciate everybody's time. I know, especially with everything that's going on in the world and an already stressful environment for you, that it is a challenging time. So we really appreciate the time that you guys are sharing with us today. So as Chris mentioned, I'm a chartered special needs consultant and financial planner here in the Chapel Hill office, and really work with folks across the Triangle in really helping them to understand the financial planning implications for dealing with both their own financial future and those who they care for. We have a strong passion for helping individuals and families with special needs, and really, want to make sure that we serve as a resource for you. So please feel free to reach out to us at any point. Email or phone call is completely fine. If you have any questions whatsoever, want to use us as a sounding board. Of course, we'd be happy to serve as a member of your team, but as a resource, our door is always open. So before we jump in, I think we wanted to really today just discuss a 10-step guide to help prepare for the future of your dependent, your child, your family member with special needs. Every circumstance is unique to you, and you should consider your own position carefully. As a caregiver, the single most important issue on your mind is what's going to happen when I'm gone. Who's going to look after my dependent's best interests? Who's going to step into my shoes? And most importantly, will my dependent be happy, healthy, and secure? So Chris, if we want to go to step one really quick. One more. So first is really thinking about planning for the future. Planning for the future medical, educational, and housing needs for your dependent. First, we want to start thinking about what will your dependent's needs be in the future, and from there, develop your financial strategy based on those projections. We always think of, especially in this environment, it's really a one day at a time thing, but taking a little bit of a step back and really thinking about what are some of the daily needs that they're going to have both now and in the future? Are they going to need therapies, skill development, employment? Importantly, as well as, what do you want them to be able to do socially and recreationally? So moving on, I think the next step is really from the legal perspective, is reviewing beneficiaries. So especially if your dependents or your children are receiving any sorts of government benefits, any assets over $2,000 in the future that they inherit can potentially cause those benefits to stop. So most importantly, we always recommend, even if your plan is secure, talking with your close friends and family to see if they have designated you or your dependent to receive any sort of inheritance or insurance benefits. If they have, it's really important that they leave this amount to your dependent special needs trust, which Chris is going to talk about in a little bit. We really don't want to let well-intentioned friends and families unknowingly cause your dependent to lose access to valuable government resources. So number 3, and this kind of goes in line with step number 2, is having a family meeting. And really from there, communication is extremely important. Everybody needs to be on the same page. Just as caring for a dependent with special needs is a family affair, so is all the related planning. So moving on to step number 4 is creating a team. Once you've determined the current and financial needs of your dependent with special needs, it's really important to pull together a support team that can help guide you through the variety of different options available to you and your family. Everybody's needs are going to be different. Everybody's desires are going to be different. Everybody's situations are going to be very different. And what's right for somebody that might be in your support group may not be the right thing for you. So the main components within a team is, number 1, on the financial planning side of things, having someone that understands really what are the implications and the potential risks of creating a financial plan specifically for you and your family. Secondly, is really having a competent special needs attorney. And what we mean by this is all attorneys in the estate realm can create a special needs trust. And we don't want to work with attorneys, especially in this very, very important space, that are the, oh yeah, we can do that too type of attorneys, right? We want somebody that knows the ins and outs, knows the exact implications, and most importantly, how that interacts and how the trust planning and estate planning is going to continue any types of government benefits and support in the future that you may be relying on now, or that your loved one is relying on now. Well-intentioned planners can sometimes make mistakes, and mistakes are extremely costly, especially if we don't have the proper things placed in the first place. Then looking into coordinating your tax accountant, health professional if needed, and of course, thinking about the social workers and maybe even spiritual advisors, among others. So step number 5, and many of you, I'm sure, look toward the internet for finding various nonprofit groups, such as the Arc of the Triangle, newsletters and publications. I think especially within this environment right now, there are a lot of different things that are changing within the government landscape, the tax landscape. So, a couple of the newsletters that we subscribe to from a national level are Disability Scoop, that really does a pretty good job of keeping us updated on what's going on across the country. And then, of course, local newsletters and publications such as Carolina Parent. Most importantly, right now, especially with social distancing, it's incredibly challenging, not just for your loved ones, but also for you. So making sure that, any of the support groups that you're currently in, if they have online Zoom meetings, don't let that go by the wayside. We're seeing more and more families become frustrated. There's more and more stress that's out there right now, especially. Your children may not understand why they can't go to school, why they can't see their friends. And that takes a toll not just on them, but on you. So make sure that any of the groups that you're within, if you're not in any, please find some folks that you can talk to online that are here locally or across the country, because you're not in this alone. So thinking about some of the more technical side of what we do, number one on step 6 is applying for government benefits, right? Kind of knowing what's out there is very important. And a lot of people put this on the back burner, but government benefits such as Medicaid, supplemental security income can help provide for your dependents' needs in the form of medical treatment, supplies, equipment, financial assistance, and more. It's very important to call your local Social Security office, and call is the important keyword here, as they aren't taking in-person meetings at this time, to find out what benefits that you or your dependent may qualify for. So many times that we find that parents just, they've got so many other things going on, they don't realize that there are resources out there from a financial or medical side that they frankly don't know about. So looking at the various types of program on the federal side, we do have SSI, various family benefits. If you do have an earnings record within your family, Social Security Disability Insurance, or SSDI, and then the Children's Disability Benefit through Social Security as well. But really finding out what you're eligible for and how to receive those benefits can help you as you're planning for the future, and find additional savings that you can place toward the future planning for your family. So moving on to number 7, I would normally at this point in person ask you to raise your hand if you have a will, but in the environment that we're in, of course, feel free to do that on your own there. But even if you don't think that you have one, you do. The state of North Carolina will decide the future of your family if you don't prepare one for yourself. I love the state of North Carolina and many other states out there. I'm sure they've got some great intentions, but I'm not sure that I want them deciding things on their own without me helping them with that decision. And if I'm not here, I can't help them. So a way around that is, making sure that you're talking to a group. Chris and his team are phenomenal, especially in this environment with technology and being able to get things done in a timely fashion. But preparing your will, not a fun thing to think about, but really what that does is declares how you want your estate to be handled, and more importantly, allowing you to select a guardian for your dependent when you pass away. Also, preparing the proper legal instruments such as wills, trust, medical directives are especially critical to help protect an individual's ability to qualify for future government benefits. So moving on, and Chris is going to talk about this one in just a little bit, but setting up a special needs trust is absolutely imperative, especially if there are going to be assets that you want to preserve for the future that won't be, for lack of a better term, stolen by the federal government before eligibility for government benefits can resume. So Chris, I'll let you take that one after we finish off the last 2 points. Step 9, and especially in this environment, setting up guardianship or conservatorship, it's a very long process before COVID-19, but caregivers must apply for guardianship or conservatorship to maintain legal control over financial and healthcare decisions once a dependent reaches the age of 18. This can take up to a year in the current environment, and even longer potentially with the delays in the court system and just overall everything else being delayed. So this is not something that we necessarily want to put on the back burner.
And I'll just chime in there, David. You can actually start a petition to apply for guardianship at the age of 17 and a half. So once a child reaches the age of 17 and a half, you can actually start that process so that by the time they turn 18, there won't be any gap in their care.
Yeah. And, it's a very personal issue, and each family is going to have their own feelings regarding this topic. So it's really important to talk to a team, especially like Chris's team, in order to figure out what your options are and to get that process started as quickly as possible so that there aren't any kind of delays or gaps that come to surprise you down the road. So one thing we don't like in the world of financial planning are surprises. So if we can avoid those at all costs, then that's great. All right. In going on to step 10, and I think one of the most overlooked things, but in our opinion, I think the most important is really developing a letter of intent. It's not a legal document. It's not binding. However, it conveys your thoughts, your dreams, your feelings regarding the care of your dependent in the future. It describes a day in the life, likes, dislikes, routines, favorite foods, thoughts on religion, dating, etc. This is a personalized document or video, in any type of format is completely fine. But really what it does is it instructs whoever is going to be helping, whoever is going to be the team if you're not there to direct them, on what are the social interests, right? My son likes to go to a baseball game each year and cheer on the Durham Bulls. Lists the doctors that you like and those you would absolutely never visit again. I'm sure that there are a couple on the list of the folks that are out there that you never want to endure, and you certainly never want your dependent to endure ever again. We can help you create one. Chris can help you create one. We've seen all types, some long, some short, some are written, some are in video format. What's right for you is really going to depend on your overall situation. And then, lastly, I think the biggest question from here is, how do you start the planning process, right? There are, various professionals out there, of course. Working with a financial planning team in conjunction with an estate planning or legal team is important. But even before that, really thinking about, the long-term objectives financially, emotionally, and how you want both you, because we don't want to forget about you guys out there, and your family to be able to live and thrive in the future. So really taking a step back and kind of listing out what are some of those top 5 objectives that are going to be most important to you, what's important to your family, and what's important to your dependent is really the first step in getting started. And then, of course, having a conversation with a team like ours and like Chris's to really help guide you into how to accomplish what it is that you'd like to accomplish. So really with that in mind, I think I'll let Chris jump into talking about special needs trust. And of course, if anybody has any questions or anything, feel free to reach out to us. So Chris, take it away.
All right, will do. Okay, bear with me. I'm just going to get the slides pulled up. All right, there we go. So actually, David, that was really useful for me too, because I spend so much of my time in just a couple of those steps, 1 or 2 of those steps at most, and I don't really get to see how the rest of it all fits together. So that was really helpful to see. So what I'm going to be talking about are different kinds of trusts that are and tools that are used for those that have special needs. The first thing I think you need to understand is what is a trust and how does it sort of operate generally, and then what's different about a special needs trust from other types of trust. So think of a trust as the closest comparison is a business, right? It's another entity that has its own name, its own date, its own identification, and it can own and hold title to property, accounts, bank accounts, real estate, just like a business could. Just like Walmart can open a bank account in Walmart's name, a trust can open a bank account in the trust's name. And so once you open up, once you have a trust, then you can then put property in that trust, and you can retitle assets so that the trust owns property now. You can name the trust as beneficiary of retirement or life insurance. And when you die, the trust receives that retirement and life insurance. Now, how does the person that takes over the trust when you die, how do they know what to do with it? Well, that's what I write. I write the rules of the trust. Just like a business has an operating agreement that describes exactly how the business is going to operate, who's in charge, what happens when they want to break up the business. The same thing applies in the trust. What happens while you guys are still living? What happens when one of you dies? What happens when both of you die? What happens when the child or the dependent that is receiving that has special needs and receiving money from a trust? What happens when they pass away one day if there's money left over? All these are sort of things that are addressed in the trust itself as part of the rules that govern it. And basically, a special needs trust can take one of a few different forms, but think of a special needs trust as a tool to keep government benefits flowing in. So, most of these means tested benefits like SSI or Medicaid, those are the ones that we're most often fighting to help people stay or become eligible for while receiving inheritance from another source. So means tested benefits like SSI and Medicaid are meant to be for people who cannot afford shelter, food, medical care on their own. And so when this inheritance comes in from mom and dad, you might have medical needs of $30,000 a month through Medicaid, but then you get this inheritance from mom and dad, and all of a sudden you can't get Medicaid until you spend down the money that you inherited from mom and dad. A special needs trust is a tool that we use to prevent that from happening. We want to have our cake and eat it too. We want to be able to get necessary, appropriate care and services for our person with special needs, and we don't want the money that we're leaving to the child or the dependent to be used for something that the government's willing to pay for. Basically, what we want to do, we want to provide above that minimum level of care. So SSI and Medicaid is not meant to live in a mansion and sip daiquiris all day. That is basic for basic needs, shelter, food, rent. It is for basic costs. And so a person who's just receiving SSI and Medicaid does not have a very high standard of living. And so a lot of times parents want to supplement that income with assets at their death to help the child live above those means. And as long as this trust is done correctly and the money is being spent and administered correctly, it is very possible, and it happens daily, where you get both government benefits and you're able to receive inheritance that the child can enjoy. So that's basically the purpose of a special needs trust. It's meant to improve the quality of life from that which basic, welfare benefits don't provide for. And SSI and Medicaid are the ones that we are most concerned about. Those are the ones that when the child reaches 18, they can get Medicaid, they can get SSI, which supplemental security income, which is basically it's for a disabled person, but it's means tested. So in order to get SSI, you have to have a certain level of assets that are very low. And SSDI that David mentioned is for people who've established enough work credits. Well, they're also disabled and they also get income from being disabled, but theirs is not means tested. So they could go out and earn income from other sources potentially, and it not affect their eligibility for SSDI. But with a child who turns 18, who's never worked, who's immediately disabled at the age of 18, they're going to apply for SSI. And when they do that, they're going to look and see how much money they have. And each year they're going to have to recertify. And if all of a sudden they get a big inheritance from mom and dad, they're going to lose those benefits. So mom and dad instead are going to leave that money to a special needs trust potentially, and the special needs trust will receive that. And the special needs trust has special rules in it that keep the money from counting against the person for purposes of Medicaid and SSI. It's not meant to replace shelter or food or any of that. It's meant to supplement. So things that aren't meant to be covered by SSI and Medicaid would be covered by the special needs trust. And so if we didn't do any planning and you died and you had a will and it all went to a special needs child, then what would end up happening is that child would lose benefits. And then in order to get it back, the money would have to be spent down so that the child can get the benefits. And the way that a special needs trust usually works is it gives the trustee, the person that you put in charge after you die, broad authority to make decisions about the best interest of the child, within rules and confines that you put into place. So it's flexible. So as the child's needs change, as they grow older, as they develop new skills, there's opportunities in the trust to use the funds for different things that may benefit the child and allow them to grow and maximize their independence. Now, there's a couple of different types of special needs trust. Now, the third party trust is the one that you typically would do if you're proactively planning ahead of time. So if mom and dad say, one day, many years from now, we will die. And when that happens, we want to make sure that money that's going to our child as part of their inheritance is diverted. It doesn't go to them directly, but instead goes to this trust with the special rules that don't cause our child to lose benefits. And so if you do that, if you create those rules and you divert the money into the third party trust, then when you pass away and that trust is funded, if done properly, the child won't lose benefits. If, however, you don't plan and the child just receives that money directly, they're going to have to spend it down. So let's talk about a third-party trust. A third-party trust is typically created when you're alive. It's its own separate entity, all right? And that's called a living trust. It just means it's created during life. So when you see that term, that's all it means. We see a living trust. It just means it's created during the life of the person who made the trust. You may also see it by its Latin phrase, which is inter vivos or inter vivos. The other type of third party trust that you might see is actually created in a will, and it's called a testamentary trust. And that's all that testamentary means is it means it's created by a will. So if you have a will that divides your property, in that will, you can direct that a special needs trust be created, and you would put all the terms into the will. So it doesn't actually exist while you're living, so it's not a living trust. But after you die, pursuant to the rules in your will, you are directing the creation of a trust and the funding of that trust. And there are good reasons to do one versus the other. It sort of depends on the situation and the types of assets you have and the child, and there's a lot of factors that go into that. And you typically see these types of trusts, these third-party trusts, whether living or created by a will, you usually see it by parents. The parents usually are the ones who create that ahead of time in anticipation of the day when they won't be able to privately pay or support the child on top of government benefits. Now, the third-party trust should be looked at in contrast to the first-party trust. A first-party trust is created typically by the special needs person or by someone on their behalf, which is different than a third-party trust, which is created by mom and dad, who are different people than the child. So the first-party trust is more reactive. So when there's money that the child receives, and we go, oh no, this is a person with special needs who's getting means-tested benefits. What are we going to do? This person is going to lose benefits. Well, not necessarily. There is a tool out there called a first-party trust. And what that tool does is it lets you, after the fact, add money to a special needs trust. Now, that comes with some consequences, which I'll talk about in a minute. But a first-party trust, and just so you guys understand all the lingo, because there's a lot of lingo that gets thrown around in this particular industry or in this sector of practicing law. A first-party trust is also called a D4A trust. And the reason it's called that, just so you have a little bit of information, is there's a long statute that describes this particular provision, and it's in subsection D4A. And so that's sort of the nickname that's come up. And the difference between a first-party trust and a third-party trust that really matters for your purposes, and the reason you may not want to wait until after the fact, is that there's a Medicaid payback provision. So whereas with a third-party trust, you can say, well, when the child passes away or when the person passes away, then we're going to give their money to their siblings or to other family members or charity. You can direct where that money goes when the child passes away one day, and if there's that leftover money. With Medicaid or with a first-party trust, you have to have a Medicaid payback provision. And basically what that means is that when the child passes away or at the termination of the trust, Medicaid has to be repaid for all the Medicaid benefits that they've given to the child during the lifetime. So if you end up having to do a first-party trust, you actually want to spend it. You actually want to spend it before the child dies, so that there's nothing left over to have to give to Medicaid, and the child has maximized their enjoyment of it. That's obviously not ideal, right? Because now we have to spend it. We don't know how long the child's probably going to live. So what if we spend it too quickly, or we don't spend it quickly enough and the person dies and there's half of it left over that we have to give to Medicaid? It's not ideal, but it's sort of a Band-Aid for people who don't plan. The other sort of downside to a first party trust is that it has to be established and funded prior to age 65. So sometimes, mom and dad will die at 90 and there'll be a 65-year-old person who with no planning. And now we have to go to other more complicated tools to deal with that. You also see first party trust in the personal injury context. So that's where you see a lot of them. Let's say a child is injured in a car accident and there's a settlement or there's a verdict in favor of the child. A court may actually order those funds to be diverted into a first party trust so that the child can get services for the injuries and things that they've sustained. And then their money will be managed appropriately by someone else and throughout the duration of their life if it's expected to be sort of a permanent injury that affects their cognitive ability and their ability to manage their own affairs. So you see it a lot there. So you see that in court. You see it as reactive planning when there's not proper planning done on the front end. But of course, ideally, a third party trust is where you want to go if you can. So this is usually where I get a question or two about, well, what about a simpler solution? What if I just leave my child with special needs out of my will altogether? What if I don't name them as beneficiary of anything? And what if instead I name the child's brother who doesn't have special needs to manage the money for them, or I name their uncle or another relative? Why can't I just do that? Just leave the money to them, name them as the beneficiary of the life insurance and retirement, name them as the beneficiary under my will, and just leave the child with special needs out with an understanding that the sibling or the other relative will take care of the child using that money. That happens. People do that. I'd say probably, I would guess, in the majority of circumstances, it probably happens without issue. But of course, I only ever see the situations where it doesn't work, when it blows up and we have to try to mitigate the problems that come up from that. And, what I tell people is when you're thinking about doing something like that, just be sure that you're okay with other people's problems becoming your problems. And what I mean by that is, let's say you have two kids, Debbie and Joe, and you say, okay, Debbie's got special needs, so I'm going to leave all the money to Joe and Joe's going to take care of it. Well, then what if Joe gets married and then gets divorced? And now all that money in Joe's name is part of an equitable distribution claim with his wife. Or let's say Joe has some major catastrophic exposure, right? Someone gets injured on his property, or he loses his job because of a global pandemic and gets in debt. And now he's got creditors coming after him. And his financial situation has just changed dramatically. Now, all of a sudden, judgment creditors that have sued him to recover money are able to tap into the money that you intended for another child. And so basically a special needs trust puts a barrier. So Joe can still be the trustee. He can still manage the money, but you put a trust in between the two of them and you administer that trust properly. And then Joe's wife is no longer a problem. Joe's creditors are no longer a problem because Joe personally doesn't own those assets and they're not accessible by Joe's wife or Joe's creditor. And so that's basically why it's not a good practice to do unless you really carefully consider the alternatives. So just to kind of recap, third-party trust is established by someone other than the person themselves, by the person with special needs themselves. So there's usually going to be parents. It holds the funds that don't belong directly to the beneficiary, and there's no payback provisions. So you can direct where the money goes when the person passes. Some things that you want to be careful of, like David was talking about earlier, there are a lot of attorneys that do wills. There are a lot of attorneys that do trusts. There's the person who does estate planning for a living, and then there's people who do traffic tickets for a living, which is an honorable profession, but then they also do wills, and they're not exposed to as much of the intricacies of this particular subset of estate planning. And so I would just suggest you be very careful, because a lot of the mistakes that I've seen in court cases have to do with someone that was trying to create a special needs trust, but then used language from other types of tools incorrectly. So there's two ways you can write a special needs trust. One is you can limit what it's used for to specific things. You can say you are to use this money only for things that aren't meant to be covered by Medicaid or SSI. You can be very specific. Or you can make it a discretionary trust. And this is probably what most practitioners and what I most often do is make it a completely discretionary trust. So instead of saying you have to only spend it on this, what we say is you have complete discretion to spend it on anything. However, the purpose of the trust is to keep you from losing means tested benefits. So we would strongly prefer, that you not do anything to disrupt that. And the reason that we do that and not make it mandatory is because we want the trustee to have discretion. The circumstances might change radically from what you understand them to be today. And the trustee may go, well, it's in this child's best interest to give them money or to do something that would cause them to lose a month of or have temporary ineligibility for benefits. We want to give that trustee discretion to break the rule if they need to for the child's best interest. And there may be some circumstances where that's appropriate. The other thing you want to make sure you don't have in a trust is what's called an ascertainable standard. And you see this, and usually what you see is my trustee shall make distributions to or for the benefit of my child for the child's support, health, education, and maintenance. Support, health, education, and maintenance, also called the SHEM standard, is an ascertainable standard. So if the trustee is in the document required to make distributions based on a certain standard, then that's not good. That's not a third party trust that's going to work. That's going to prevent ineligibility. And so and just like I mentioned earlier, you can create that trust now, and you can fund it now if you want. But you can create the trust and then name it as beneficiary of property, or you can establish one under your will and have it created at your death. Both are okay under certain circumstances. Both options are okay. There may be one reason or another to pick one over the other. One that comes immediately to mind is if other people want to name your child as beneficiary of property. If you have brothers and sisters out there that want to leave their estate to your child, you probably want to have one that exists now, so that if they die first, their property will go into the special needs trust. But there are other factors that you might want to consider. A first party special needs trust, this is when it's too late, right? We didn't plan, or we didn't plan right. I've seen people who come in with wills from criminal defense attorneys and special needs children, and they think they planned, but they didn't. So if someone didn't plan and it's the child's money at this point, so if I have a will or I don't have a will and my children with special needs are now the beneficiaries of my property, now it's too late for them to do something about it, except we can go to a first party special needs trust. And another, definitional thing that I think might be valuable as you're doing some research on this, a third-party trust, the one we just talked about, where you created ahead of time for the child. A third-party trust is it's special, first of all, because you don't have that payback, but you also have the ability to fund it. I mean, you can have it doesn't matter if the child's 90, right? You can have a third-party special needs trust for a child. With a first-party special needs trust, you have to have it has to be created and funded prior to age 65. And so with a first-party special needs trust, you got the person's own assets that you're using because it's too late, and usually it's going to be a legal guardian or it's going to be a court that orders the establishment of the trust, unless the person does have capacity, which does happen from time to time, where you have a person with special needs who has capacity to sign documents and do things, but they are still disabled. Sometimes we can get the person directly to sign. So a lot of the difficulty of handing the reins over to someone else is finding someone in your life to hand over the reins to. I probably sit down and have 20 or 30 consultations a week. And, I get to these questions, and most people only have a couple, if even that many, a couple of people that they trust with a responsibility like this. This is different than a typical trust. In a typical trust, it's mainly going to be financial, right? It's going to be a discussion. The trust will say, split it 4 ways. Okay, well, that's math. That's not interpersonal connection with someone that you have to know really well to split something 4 ways. With a special needs trust, it's a little different. You're going to have to know a lot about the child, their needs, their caregiver, their treatment team. You're going to have to be sort of more intimately connected as a trustee than you would in a typical trust. That's just my opinion. And so you want a trusted family member, I think, is usually the first priority. I think that's who you want to go to first. If you have somebody like that, that knows your child and your child's comfortable with and can communicate on behalf and advocate for your child, I think that's who you want. If you don't have someone like that, there are lots of other organizations out there. A couple of things to keep in mind. There are corporate trustees out there, like big banks, right? BB&T, Wells Fargo. They are corporate trustees, and they can be named in a document to be a trustee. Now, a couple of things to keep in mind. A lot of those banks or a lot of financial institutions that have trust departments don't accept special needs trusts. The reason for that is because they are so complex. There is a tremendous amount of liability with a special needs trust. So even if you name a family member, your family member will probably want to hire an attorney to make sure they're doing it correctly, or find someone who's familiar with this to make sure that they're doing it right. But there are, and the other thing to keep in mind about corporate trustees is they have a schedule of fees that is usually much higher than an individual trustee would charge. So, but there are a lot of people who want to make sure it's done right, and they want to make sure that it's by somebody that's not associated with the family that has some interest. So if you're in that boat where you want to keep it separated from the family, a corporate trustee might be a solution. But keep in mind too, that a lot of them have limits, have a minimum threshold. So some of the big banks, they don't want to be trustee unless there's at least $2 million in assets at the beginning of that, at the beginning of the process. And some have $500,000. The lowest I think I've seen that actually had a limit or had a minimum was $100,000 through a credit union. But there are various corporate trustees you can investigate. Another thing to keep in mind if you're thinking about a corporate trustee is if you have real estate, you'll want to specifically address that as you're interviewing potential corporate trustees, to make sure that they can either handle it or they have a process for dealing with it. Because some of the corporate trustees that I've dealt with in the past, they refuse to take cases that have real estate, which is kind of unusual because a lot of people have real estate. One nonprofit that's come to mind recently is the Corporation of Guardianship. So that's a nonprofit organization that specifically does accept special needs trusts. So if you don't have a trusted family member, or perhaps you want to name some backup options in case your child outlives those folks, a nonprofit is a good thing to look at. Now, what happens if the child receives money? So the child may be able to work. The child there may be a crisis, and we might have to give money directly to the child, which is typically forbidden in a special needs trust. And so, what happens if the child gets money? So if the Social Security Administration deals with SSI, so supplemental security income, and basically they said if you give cash to the person or you give actual product to the person, you give them something in kind that will enable them to provide for their own shelter or food or things that SSI is meant to pay for, then what you're doing is you're lowering their amount that they can get that month. And so if someone has, let's say you just give them a gift of $20. If you do that, then that technically is unearned income, and that's the maximum amount they can earn in a month. And then everything above that that's unearned by them, it's not earned income, is counted against them. And so they dollar for dollar, you get a reduction of your SSI benefit for that month if someone gives you money. And so typically what you want to do with a supplemental needs trust or special needs trust is you want to have it, you want to use the money for the benefit of the person and not give them money directly. With earned income, so if you have a person, a dependent with special needs, and they're earning income, they have maybe a part-time job or something, they can use whatever they have left of the unearned income credit or exception, and then they have another 65 they can use, and then it's 50 cents to the dollar counted against them after that. So basically, if they receive money, there's going to be, in a particular month, there's going to be a consequence. But your trustee in a particular month might think, you know what, that's okay. We need that. That the situation warrants a reduction in SSI for this particular month, and they can make that decision. So a lot of times, people want to know what kinds of things are covered and what the kinds of things aren't. And so SSI is meant to cover the things on the list here, food, mortgage, taxes, rent, gas, electricity, water, sewer, fuel, heating. But surprisingly, to a lot of people, telephone, cable, internet, yard, pool maintenance, those things are not covered. And so you could technically use special needs trust money to fund all of those things, to fund telephone, cable, internet, et cetera, because it's not something that SSI is meant to cover. And so you're not going to get you're not going to get a reduction in the benefits for that month because you spend money on the telephone bill. But it basically, if it's not one of these things or something that Medicaid covers, you're probably good to spend special needs money on, or special needs trust money on it. And then as far as lingo is concerned, I did want to clarify one thing. A third-party trust is called a supplemental needs trust. So when you see the phrase supplemental needs trust, that exclusively, I think, refers to a third-party trust, one that's created for the benefit of a person with special needs. A first-party trust is called a special needs trust. And that's where all the confusion happens when you read stuff online. And so a first-party trust, one that's created because of no planning or because of a personal injury settlement or something like that, those are called special needs trust. Now, the phrase special needs trust also colloquially refers to both third-party and first-party special needs trust. So if someone comes in and they say, I have a special needs trust, I really don't know it immediately whether they're talking about a supplemental needs trust or an actual first-party special needs trust. So just keep that in mind as you're looking through stuff. When they say special needs trust, they may or may not be referring to a first party or a third party, and that may cause some confusion in your research. The last thing I want to talk about is ABLE accounts. That was, I think, done. That was a law that was created during the Obama administration, and basically it allows people with special needs to have some additional freedom to spend money, to exercise some independence. It's a really good program. But there are a few rules, and so I just wanted to go over them with you as you consider incorporating this into part of a larger plan. First of all, it's for those who are blind or disabled, but they have to have that initial diagnosis before they're 26 years old. And then each year, the child can only receive up to the gift exclusion amount. So I don't know if this is sort of a tax term, but every year there's a gift tax exclusion amount where you can gift a certain amount of money before it counts against you for estate tax purposes. And it goes up periodically. And I think right now it's at $15,000. And so the child can receive up to $15,000 a year into that ABLE account to be used for the benefit of the child. The child can use themselves for their own benefit. And the growth in it is sort of like a 529 or a Roth. The growth in it is tax-free as well. So it's sort of like having I think it is under the 529 laws, but the rules are very liberal. I mean, you can use the money for just about anything. It gives you a lot of freedom, but it has a payback provision. And so just like a first-party trust has that payback provision where if you spend too much, or I'm sorry, if you die and there's money left in the account, then it has to go to pay back Medicaid first. So the same thing applies to an ABLE account. So you want to keep the balance moderated. You want to know how much is in it, and you want to be able to keep it at an appropriate level so that if the person does suddenly die, you're not losing a great deal of money to Medicaid. If you do get more than $100,000 in that account, in that ABLE account, your SSI is going to be suspended until it gets under that $100,000 limit. The good thing about this is a lot of the special needs trusts or supplemental needs trusts that I create for clients, we incorporate ABLE account language. So even though the child can't have money directly, in general, under the rules of a special needs trust, they can't receive cash directly. They can't receive the in-kind benefit directly. What they can do is have a deposit made to their ABLE account, which they then can make that decision about on their own. And they can then spend money on their own. So it's sort of like having the best of both worlds, but with one little consequence of having that payback provision. But you can create in a third-party special needs trust or supplemental needs trust, you can say, and my trustee has the discretion to create and fund ABLE accounts. So to grant my beneficiary additional freedom to spend money and exercise independence. I think it's a great tool for folks that it fits into. So I did want to do a little plug for the firm. We are doing a promotion. As you guys all know, like COVID has just made people rethink everything. And so people are beating down the door right now to get their wills done and trust done, and they just want to make sure their estate planning is in place or get it updated because they haven't paid enough attention to it. And so we're trying to encourage that because we think it's a good thing. And so what we've got right now is a special going on. If you go to estateenc.com and you use the promo code #event25, that will give you access to my calendar, and you will be able to schedule a 25% off. But basically, the consultation's free, but I will know from seeing the calendar entry that you have entered this code, and I'll be able to give you 25% off the regular price of services for any estate planning, special needs trusts, wills, anything that's in the estate planning category. So feel free to take advantage of that offer, and I will go to questions at this point. So one of the questions I got is, are there any special considerations when dealing with a loved one with substance abuse? So that's kind of a different animal, unless the person also has special needs. But there are some special considerations that you want to have. And what you probably want to do is create a different kind of trust for that. If you have a spendthrift, which, someone with substance abuse problems spends money recklessly on substances, you may want to prevent them from getting too much too quickly. And there are other types of trust and tools that you can use to dole out inheritance to those who aren't suited to receive and manage money themselves, separate and apart from those who have special needs. This tool is more meant to ensure continued government assistance, which you could do, I think, theoretically for someone with substance abuse, but it's just a whole different animal. Let's see if David's still with us. And a D4B trust, not something so one of the questions was, can you create a D4B? I'm actually not that familiar with D4B trusts. It's not something I've ever had to deal with. That may be a pooled special needs trust, which there are organizations that exist. So for example, if you're over 65 and you need to do a first party trust, there may be some consequences that I just don't mess with pooled trust that much, but you may still be able to get into a pooled special needs trust. A Miller trust, there was a follow-up about that, about involving a Miller trust. So a Miller trust is actually kind of an interesting tool. For those that don't know, Miller trust is more for Medicaid planning generally, not necessarily Medicaid planning for those with special needs. But that is actually only available in certain states. North Carolina is not one of them. We don't recognize for Medicaid eligibility purposes the use of a Miller trust, unfortunately. And so when you think about Medicaid, a good way to think about kind of the map of how Medicaid works is that there's this federal program called Medicaid, and they have a whole bunch of rules. And then each state has their own, each state administers their own Medicaid program, and they're allowed to pick certain rules within the federal guidelines. And so each state picks a different combination of rules. And so every state, when it comes to Medicaid, is completely different. And so a Miller trust, you look it up online, it goes, oh, Miller trust is a great tool for Medicaid eligibility. But in reality, that's only the case in certain states. So another question we had was, what are your thoughts on having a life insurance policy that pays off a mortgage so that the adult child and staff could stay in the home? I think life insurance is an excellent tool to supplement a special needs trust and your other planning. I think second to die policies are really popular. I think David can probably speak more to that, but a second to die policy is a policy where there's like usually two parents, a married couple, and then at the death of the second one, then the policy pays out. And there's some benefits to doing it that way as opposed to having separate policies. I think David can explain more. But I think it's a critical component. Mortgage specifically, though, is actually interesting. I think you can, I know lenders usually don't push this product, but I think most of the time with a mortgage, you can actually purchase a life insurance policy just to pay off that mortgage instead of having your own separately funded policy. I don't have a whole lot of familiarity with that. I do think, generally speaking, having a life insurance policy of some type of fund trust to basically create a large sum of cash assets to deal with all the administration costs and all the costs of, handling your final affairs of getting houses sold or getting houses, remodeled so that, they're accessible for longer and the child doesn't have to go into a facility for longer. But yeah, I think life insurance is probably, I've never sat down and had a conversation with David for, purposes of trying to help a special needs child. But I imagine that insurance would be probably in the top 3 things he would discuss.
Yeah, and Chris, just to build on that, so typically on the mortgage insurance specifically, a lot of lenders do offer it. Oftentimes, if you can procure traditional life insurance mechanisms, the cost is going to be significantly less over the lifetime, and it doesn't end at the time that the mortgage ends. So you also mentioned the second to die, also known as survivorship policies. Mm-hmm. And really the major benefit for these for families with special needs is kind of twofold. Traditionally, life insurance is to, mom buys life insurance on dad to protect the family if dad's no longer here, and vice versa, right? And that term typically ends at retirement. However, when you're planning for the future of your loved one, we've got to really think of this. And the best way of thinking about this is actually from one of our clients, and I thought it was a great idea, is thinking about 2 retirements, right? Because you're not just planning for years, you're planning for your loved one as well. So having a permanent type of insurance that goes beyond retirement is much more important when we're thinking about special needs, trusts, funding, and other costs that come down the road. And number 2, because if you're thinking of the survivorship or second to die policies, they're much less expensive because the risk is offset between 2 individuals versus 1. So it's much more cost effective if you're wanting to fund a special needs trust, pay off a mortgage, do really whatever you want to with it, in that the amount, it's permanent, it's going to be there, and it's much less expensive than a traditional single owned policy. And it's available immediately for funding after the death of the second individual. So there's not a wait time. It's immediate liquidity, funds into the trust, and we don't have to deal with any other types of provisions and back and forth with different investment companies and legal folks and everything else. So it provides that immediate liquidity. So
I did want to go back to Tasha's question. A D4B trust is actually another name for a Miller trust. It's just that because I live in North Carolina, I never have to draft them. I didn't know that. But I know that now. Thank you, Tasha. I don't see any more questions. So I think we have successfully educated everyone in the room. David, is there anything you wanted to add before we part ways?
Well, certainly. And if anybody wants to reach out to our team for a consultation, we are using video and screen share conferences. Any consultation is completely free. So don't feel like you have to bring a checkbook. And we'll be happy to share some ideas and see how we might be able to help you and incorporate with Chris's team as well. Our contact information is mmc2100.com. You'll see it coming soon. You would also be able to reach me directly at 919-619-2894. And lastly, my email address is david@mmc2100.com. So again, feel free to reach out to us. We're here to help. And, if you have any questions down the road, please feel free to reach out to us. And thank you, Chris, for having us today, and Salem, of course.
It's our pleasure. And I think everybody's found it really informative. I certainly have. And to answer Tasha's last question, yes, David is able to handle life insurance policies and helping you get that. Looks like we might have one more question. Oh, no, we don't. We're good. So, all right, guys. Well, it's been a pleasure helping you guys out. And if you have any questions, please feel free to follow up with us. I think we're both available and would love to be a resource for any of you. And please share this video with your friends. I think it'll be recorded, so you can continue to share this link even after this video is done. So thank you guys again, and feel free to reach out to us if you need a resource. Thanks so much.
Bye, guys.